Morning, folks. My name is Ben Nuelle, Public Policy Director at the Iowa Pork Producers Association. Thanks for joining us this morning. Real quick, we have surveys here. If you'll see at your tables, please, we'd appreciate you filling those out once the session is over. And I want to take a quick moment to introduce myself as well as Eldon McAfee. So I'm the Public Policy Director, as I said, at Iowa Pork Producers, covering state and federal policy and environmental programs. Previously, I served as a reporter in Washington, D.C. for AgriPulse Communications, as well as a reporter for an Iowa radio network here in years prior. The next man, I pretty much think most of you guys know him, Eldon McAfee. Graduated from Iowa State University with a degree in farm operations and then farm before attending Drake University Law School. He was with the Des Moines law firm Beving, Swanson, and Forrest for more than 23 years until several years ago, where he went to Gentry Law Firm and formed the agricultural law group there. Eldon provides legal counsel for the Iowa Pork Producers Association, Iowa Cattlemen's Association, Iowa Poultry Association, and other Iowa farm organizations, as well as livestock, crop producers, and ag businesses. So Eldon, take it away.
All right. Good morning. Thank you. Well, let's start with logistics. There are outlines, hard copy of what we're going to cover here. They're on a chair in the back. If you didn't get one when you came in, maybe someone can help or you can grab one. We've got plenty. And, people give me a hard time about my slides. I violate every rule there is, I think, anyway, on PowerPoints. You're supposed to have just a basic concept. And no, you get everything with me. I cram as much in there as I can because, I like to give you something you can take home and read in detail, which I know you all do, right? But seriously, I do try and give you something that can be a reference/resource, and we'll cover again. There's 70. What is there? I cut one out. 69 slides today, but we'll not go through every one of those in detail, and some of those at the end we may not get to. But again, I just I hate to leave something out, so we like to cover a lot. Much to the chagrin of some of the organizers who look at what we try and pack in here, Ben. But let's look at the table of contents first. How's that for a PowerPoint with a table of contents? We're going to talk about ag nuisance here in a little bit, and then ag fraud and trespass laws. If you're wondering what that means and you're used to a term, ag-GAG, I don't use that term. It was a term coined by our opponents, livestock opponents in the media that here a few years ago, and it's caught on. No, it's ag fraud and trespass laws. Okay? Then we'll talk briefly about California Prop 12 and Massachusetts Question 3. I say briefly because there is a full hour presentation this afternoon. I believe it's this afternoon.
This afternoon at 2 o'clock.
By NPPC's legal counsel, Michael Formica, and he obviously will go into more detail, but we'll just mention it there. And then manure easements/agreements. That's a topic. Is there a lawsuit there? A major lawsuit anyway? No, but there, as we've seen before, and we're seeing now with fertilizer prices, where they are, I'll put it that way. We've always seen interest in manure the last few years, and I think we're seeing more now. And I just want to go over some of the issues in a manure agreement. I call them manure easement. I'll talk about the difference, and I'll start out with some court cases. I'll stop here for a second. I give this talk to attorneys quite a bit on agricultural law through the years. And one thing and many of them are attorneys who don't do a lot of ag law, and they find it interesting, and I emphasize the court cases we see are not over who has to take the darn stuff, right? Which is what many people would think. The court cases we see are who gets it. It's that valuable. You folks know that, many don't. It's valuable, and there are people will go to court over, no, it's mine, and we'll talk about some of those cases. And what I would encourage producers consultants and attorneys to look for in putting together a manure agreement. And I'll quit saying what we're going to get into, and we'll get into that after a bit. And then the big part of your contents here is DNR issues, and some are recent. We'll cover those and hit some of those high points, but there are a lot of slides there we won't cover. We'll skip around or skip through them, but I wanted you to have those slides as a reference. And the way I like to do a talk, Ben and I both we'll take questions as we go. So if we're on a topic, I like to tell you what we're going to do so you can see what's coming up in case you have a question. And we'll take questions as we go. We have a traveling mic here somewhere, and raise your hand and someone will get that microphone to you so that your question is on the, we're recording today, it'll go up on the website, so we'll handle it that way. Okay? Ready to go, Ben?
Sounds good. Yeah, let's get into this ag nuisance cases and kind of where we are in terms of what we're seeing on the landscape here.
All right. Well, here's where we're headed, folks. We'll have a slide here in a minute on a major decision that came out in June by the Iowa Supreme Court that found our nuisance defense, one of them here in the state of Iowa, constitutional. I hate to talk about what I've been doing all these years, but starting in 1998 and until this, nuisance lawsuits have taken up a lot of my time. The Iowa Supreme Court in 1998 found one of our nuisance defense laws unconstitutional. And there's been a long road, but I think we got as close as we're going to get this past June. Now, let's talk about some of the situations, I'll call it, that got us there. On slide 3, I talk about there are a couple of nuisance trials that were in 2015. These are cases that went to trial. Juries decided, is that a nuisance? And by nuisance, we're talking about odor. Odor by far is the biggest issue. Flies often get discussed, etc. And what is a nuisance? Unreasonable interference with the use of an enjoyment of someone else's property. Juries decide, is that a nuisance or isn't it, after a lengthy trial usually. A couple cases there, one in Powesheet County where the jury ultimately it ended up a $462,500 award to one neighbor. That was in 2015. Then starting in 2016, we had a case in Wapello County, and I've got the details there for you. And the jury, after hearing all the evidence, both saying it was a nuisance by the neighbors who were suing and by others who said it isn't, the jury determined it was not a nuisance and no money was awarded. Next slide, what do? I throw in Illinois and Minnesota cases. I've talked about these before, and I know we have visitors, obviously, from those states. 2 cases there, 16 and 17, where juries found not a nuisance. I don't have the North Carolina slide in here this year about the large jury verdicts that occurred in North Carolina, but I'm focusing on the Midwest here. Okay, what happened then in 2019? And keep in mind, folks, this is before we had the protection that the Iowa Supreme Court affirmed for us this past June. This was there was some nuisance protection provided in some of these cases, but by and large it was juries deciding, based on the evidence, testimony of witnesses, was there a nuisance? And in Buchanan County on a cattle operation in 2019, 500 feet away, right across the road, 2 houses, 3 plaintiffs, and the jury found no nuisance, based on the testimony that was presented by people who, one was a mail carrier, etc., tenants who lived in the house right by the feed yard, and yeah, there was odor, but no, it was not a nuisance. Then we go to a month later in Henry County, 3 hog operations there. I got set that out in that bullet point, and a lengthy trial, 3 weeks, and there you can see how far away the people lived, and the jury found no nuisance. So those were in 2019. I realize we're in 2023 here. Here's a summary slide, and I've used this before. Slide 6, And basically go down to the second bullet point and see from 1994 to 2004 in Iowa we had 7 ag nuisance trials, 6 swine, 1 grain drying and handling, and 6 verdicts finding a nuisance. So by and large the juries were finding, based on the evidence presented, to be a nuisance. Then we had a lull. Then we go from 2008 to 2019. We, again, 7 trials, 4 swine, and 3 cattle, and just 1 finding a nuisance. And that was the one I mentioned from Powesheet County. And then, like I just noted, the last 3 trials, no nuisance. So, of course, Ben, as you have been in this position for a year now, but as you and I have talked about, the juries were headed in our direction as livestock producers, and you don't hear that much from the media out there. It's always how terrible things are. But juries, those who are hearing the evidence, were finding that even though the neighbors were complaining of nuisance and were suing for nuisance, that you could see the tide had swung, so to speak. All right, now let's go to the other side. What was the legislature, the Iowa legislature, trying to do for us? Well, first of all, mediation is required. Insurance, standard farm liability policies don't normally cover a nuisance due to the pollution exclusion, etc. Environmental policies are available. If you're, we'll leave that up to you, but talk to your insurance provider about if you have a concern about what coverage you can get from nuisance. But what we were also finding with some of the jury verdicts coming out of the state to the south of us, Missouri, and also and then when the North Carolina verdicts were coming out, the large verdicts, it was very hard to get nuisance coverage here in Iowa. These last 2 or 3 trials have helped, but we'll get to what should really help us here. All right, 98. Iowa legislature adopts the animal feeding operations nuisance. Basic premise here is you have to follow generally accepted management practices to get the protection. If you're not doing a good job of following these practices, we have them in the handout, then you don't get the protection of the nuisance. All right, that was in 98. I'm jumping ahead here to 2017. The Iowa legislature adopted what actually is the 4th nuisance defense Iowa has. And that's where we pretty much put a limit on damages, we being the state of Iowa. If there's a nuisance, it's limited, and the jury finds a nuisance, then they look at, is there a decrease in market value of the property of the neighbors? If so, then the damages are limited to 1.5, decrease in property value plus 1.5 times that. That's the limit on the jury. We've never had to use that yet, although one of the courts was ready to use it in one of the cases I talked about. So those are the laws that are in place to help us. So here's a summary of that, slide 10. 98, the ag area law was found unconstitutional. 2004, that 1998 AFO nuisance defense was found unconstitutional as in violating inalienable property rights. So Iowa was the only state at that time, and we'll talk about what the Iowa Supreme Court said about that here in June, that had their law found to be unconstitutional. We had no right to farm law protection. We were on our own. Well, then in 2018, the Iowa Supreme Court kind of reined it in a little bit and said, well, they at least we have to have a particular proving that you haven't qualified for those factors prior to going to trial. Some help, but we weren't quite there. All right, here's the slide I've been talking about. Slide 11. June 30th of this year, June 30th or past year, 2022, the Iowa Supreme Court pretty much said, in my opinion, enough's enough. We've been through this. We keep getting these cases. The Iowa Supreme Court rejected their 2004 ruling on those 3 factors, and then, as in the 28 ruling, and said that decision was wrong. Now, it was a 4-3 decision, so yeah, it was a squeaker. But that was an outlier. It was an outlier in Iowa and nationally. No other state had ever, and I have a specific bullet point on that. And then the Supreme Court turned it over to the legislature and said they had the right to enact the AFO nuisance defense. Quote, balancing the competing interests of CAFRO operators and their neighbors is the legislature's job, basically is what they said. And noted that all 50 states have some type of right to farm law, but no other state Supreme Court has ruled their law unconstitutional. And when it was challenged, the state Supreme Court rejected the constitutional challenge. So we were on our own, and now we're not. Okay? So we're home free, right? Well, you know an attorney's not going to sit up here and tell you that. Exactly. Yeah. All right. Here's my analysis, and then we'll get to what we'll have a little discussion here, a little coffee chat. How's that? My analysis is the Iowa Supreme Court returned the livestock producers to having protection from nuisance lawsuits as enacted by the Iowa legislature. Started in '98 when it got thrown out. It took us this many years till 2022, but the Iowa Supreme Court has given us back what the legislature has repeatedly tried to give us. But livestock producers cannot take that for granted, and to qualify for that protection must continue to use good management practices. The same practices that juries have found effective. So I guess to me, it comes together here. This wasn't a situation that, like North Carolina had. They enacted a new right to farm law following the big jury verdicts. And nothing against North Carolina, but we didn't have that here. Juries were coming around, as you saw on that slide. The last 7 trials, only one was found to be a nuisance. So juries were finding on their own at least those that were presented to a jury were not a nuisance, except for one. So we had juries finding based on the evidence no nuisance, and then we had what the Iowa legislature had tried to do, and the courts in Iowa had rejected it. I think the Iowa Supreme Court acknowledged that, and the fact that no other state had done what Iowa had done. Okay? What are those factors? And I've had this slide up for many years here at Pork Congress and other places. What are those practices we need to use? You can think of your own, but location, 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 prevailing winds, tree buffers, building ventilation management. What the heck is that? That's, you decide, what's best for those pigs is what's best for the neighbors as well, because good ventilation means those pigs will stay clean, right? And clean pigs don't make near as much odor as pigs who are not clean, and often it's because of the ventilation. Does that mean, some sort of biofilter or odor fence or whatever, electronic odor fence? If that's what works in your operation, that can well be one of those practices. Is it always required? No, I don't think. It depends on your operation and the neighbors, etc., and on over to all the other factors. Okay? So, all right, I went one slide too many. Let's wrap this up. Iowa Supreme Court has ruled you have a nuisance defense. It doesn't apply to decrease in property value. So if they can prove a nuisance and it decreases their property value, no nuisance defense can provide you with that protection. Okay? But that's not where the large damages usually come from in court. Those are I can't sit out on my deck at night, I can't have neighbors over, it's ruining my life, etc. That's where the large money awards come from. The Iowa Supreme Court has said if you follow the generally accepted management practice reasonable for your operation, then you have the protection of that law. And you might say, well, the juries were already finding that. What's the problem when juries find for you? You had to pay people like me to get there. And I'll smile and say, we ain't cheap, folks. But seriously, there's an expense there. What this law is saying is if you can show you've met those factors, one, will the lawsuit even get filed? Or two, it doesn't even then, hopefully, can get out on what we call summary judgment prior to trial if a lawsuit is filed. So, With a combination of factors, knock on wood, I hope we're in the right position now. First of all, as we sit here today, I'm not aware of any lawsuit in the state of Iowa filed against an agricultural operation, mainly livestock. I'm not aware of any. Now, there's no central filing place I can go type in nuisance and look for them. I'm not aware of any, and that's the first time I've been able to say that for quite a while. Let's keep it that way. Let's not think that we have a free rein here. Keep up the good management practices as producers. Get that insurance in place if it works for your operation. And just, again, keep doing the job we're doing. Any questions about this? Ben, you've been through this. With anything I haven't covered that I should emphasize?
No, I think the main thing is just making sure producers understand, landowners understand what they need to do to not get in a situation like this. And I think understanding these management practices and making sure they do those is kind of where we need to go. Can you talk about the ag fraud laws as we come up here next and where we're at on some of the statuses with those and,
Sure.
and what we're going to talk about here?
That's where we're headed next. Okay. And of course, we wanted to spend a lot of time with the nuisance issue. That was the headliner, so to speak, here. This is where ag fraud laws. Iowa has adopted, as we're going to talk about, basically 4 of them. Other states have tried. The courts, laws that make it a crime for someone to enter your operation that's not supposed to be there. Okay? That's basically it. Now, other people will describe them differently than that. They take videos, etc. But the premise of the laws is it's a crime for someone to come on your property if it's your operation, if they're not supposed to be there, and depending on what they do, the crime can get worse, etc. It's basically a trespass. Well, slide 14 there, we started in 2012 as a state and adopted a law, the ag fraud law, that it's a crime to use false pretenses to obtain access to an ag facility, and it's a crime to make a crime to make a false statement or representation on a job application to be employed. All right, that was in 2012. Well, if we go to the next slide, then I skipped ahead of the district court. The U.S. District Court in 2019 found that law unconstitutional. So it goes up on appeal to the 8th Circuit. We're talking federal courts here, not the Iowa courts, not the Iowa Supreme Court, but federal courts. This decision came out a year ago. We talked about it last year. And this is a major decision that you didn't hear a lot about because it was one of the first decisions. There was an Idaho decision that upheld part of the law. This decision from the 8th Circuit upheld part of that law and found the unauthorized access portion to be constitutional. It didn't violate anyone's free speech rights. They did find the employment part, making it a false statement on it, to lie on a job application. And I use the term lie because that's what the courts use, to give false information on a job application. They found that was too broad and found it unconstitutional. The key with this decision, and you'll see it, that's the only decision we have out of the 8th Circuit now. And they're the appeals court above, of course, the federal district courts. But the key here was the court ruled that, let's see, did I have it more detail in the next slide? No. The court basically ruled property rights are paramount. The right for you to exclude someone from your property is paramount, and the cited a U.S. Supreme Court decision. And to me, the real struggle here with these laws is the right to free speech, which our country holds very highly, which it should, and our courts do, but the right to exclude people from your property that aren't supposed to be there is just as important, and this court found that it outweighed the right to exclude others from your property, outweighed any free speech concerns here. And I think that's the tussle we see in all these decisions. Other courts have went the other way. But let's take a look then. well, let me just point out briefly there, and that be the second bullet point, then the sub-bullet point underneath it. What the courts had ruled before is, okay, so they trespass. What's your harm? What did they do that really harmed you? Did they take something? Did they break something? No. They went onto our property, and yeah, they take videos, etc., but they were not supposed to be there. They trespassed. The lower court had said, yeah, so they trespassed. That's not a legally cognizable harm. The Eighth Circuit, because it really didn't hurt you from, they didn't steal, they didn't break, or whatever. The Eighth Circuit said, based on a U.S. Supreme Court case, they said, no, that doesn't matter. They violated the law. They entered your property when they shouldn't have been there. That is enough to be a legally cognizable harm. So I hope we've got 2 more cases going up to the Eighth Circuit. Our 2019 ag trespass law, using deception to gain access to or employment at an ag production facility with the intent to cause physical or economic harm. That was the 2019 law. This same U.S. District Court, the District Court, not the Eighth Circuit, looked at that law in March and said that's unconstitutional. Now, the Eighth Circuit had already ruled on the previous law. That court decision barely even mentioned that Eighth Circuit decision, and instead referred to a decision out of Kansas in the 10th Circuit that had went the other way. Anyway, that is now up on appeal to the Eighth Circuit. The briefs have been filed and oral arguments haven't been scheduled, but we're hoping the Eighth Circuit takes the same position on your right as a property owner to exclude others, okay? Then we also have the food operation trespass law adopted in 2020. This one has not been up to the federal courts. I explained what the law is there. Here's the court decision we have, which came out in 2022 before Pork Congress last year. I talked about it briefly right before Pork Congress. This was where a defendant was charged with trespassing at a hog operation. It was to go to trial in Wright County. Prior to that trial, and for a lot of various reasons, the case was going to be dismissed, okay, by the state that was bringing the trial, okay, or bringing the charges. But prior to that, there had been a motion filed by the defendant being charged with the food operation trespass, that it was unconstitutional, violating free speech. Well, the normal challenge we see. The judge, prior to dismissing the case at the request of the state, went ahead and issued that decision, and that decision ruled that it was not unconstitutional, upheld the law based on the Eighth Circuit decision. That is the only decision we have on that law right now, but that law has not been challenged in federal court. I'll try and wrap all this up here a little bit, okay? I know it gets a little confusing on who's on first. But then in 2021, we had several laws enacted. The livestock transportation law, it has not been challenged in court. Unauthorized sampling as part of trespassing, I guess, that has not been challenged. That was a 2021 law. And then we have the electronic surveillance law. Now, this is not even specific, to livestock operations or even ag operations. This applies to property. A person committing a trespass who knowingly places or uses a camera or electronic surveillance device that transmits or records images while the device is on the trespass property. First offense is an aggravated misdemeanor and then a Class D felony, which increases the penalties over your normal trespass law. Well, that has been challenged in federal district court, filed a year ago, and then on September 26th of this year, and I think many of you read about that decision, found that it was unconstitutional as a violation of free speech rights. Much of the same analysis relying on the Kansas 10th Circuit decision versus the 8th Circuit decision, and that case is now on appeal. All right, let's see where we're at. What I try and do, slide 24, is summarize. Here, I'll go back through this, but right now, for you as livestock producers, I can tell you, one, we do have protection for trespass. Those who come onto your operation, didn't get permission to be there, shouldn't be there, we have protection through the Food Operation Trespass Law and the original 2012 law as far as criminal protection. What we don't have criminal protection for is those who lie on a job application to work at an operation and then turn out to not be who they say they are and do whatever we read about they do when they get there. We don't have a law right now that's been found to be constitutional in the state of Iowa for anyone who does that. Those have been found unconstitutional. We have those two that are up, or at least the one that's up on appeal to the 8th Circuit. We'll see what the 8th Circuit does with it. Okay? All right. I think that slide pretty much summarizes that. I know we get a lot of questions about, okay, where are we at? I try and boil it down to what I just said. Okay? Any questions on that? What about practical steps? We sit here and talk about criminal law. I mean, nobody has the right to come on your property if you don't want them there. Okay? Well, okay. If the cops show up, you might... No, just kidding. All right. Federal EPA even kind of fits into that category, but that's another subject. What are the practical steps? You producers and consultants, etc., can probably add to this list, but this is a list I come up with. Maintain physical security, locks, etc., electronic security, video surveillance, etc. You can do that on your property, okay? Continue what I call the time-honored approach to security, such as posting no trespassing signs, etc. In the employment context, and I put right in here, although maybe easier said than done, including by attorneys sitting on a stool at Pork Congress giving you a seminar, easier said than done, conduct extensive and detailed interviewing of job applicants, adopt animal welfare policies and train employees in proper animal husbandry, and instruct and encourage employees to report anyone who is not following those policies. Excuse me. Anything I've missed there, folks, or any questions about it? Ben, you talk with producers about this area.
Yeah, I think just one of the main things is how do you interact if you have problems on your operations, and that's something if you guys do see folks out and about acting suspiciously, let us know. We want to know how we can help you and be resources at Iowa Pork if we have these types of situations happen, for sure. I guess we could move on to California Prop 12 briefly. Obviously, Michael Formica with the National Pork Producers Council will have a seminar this afternoon at 2 o'clock that I'd encourage all of you to attend if you're interested. But Eldon, can we kind of get a brief update here on where we're at and how this differs? Because I get a lot of questions about Massachusetts Question 3 as well. And so explain kind of how the differences are between these two rules here.
Well, how about if I can just go to the legal analysis and that they're all on hold right now. How's that? But waiting on the U.S. Supreme Court decision. Somebody has to raise their hand and ask me, when are we going to get that decision, right? I don't know. All right? Michael will talk about that, I'm sure. It should be coming sometime in the next few months, but that's the main question I get. When, first of all, it's I think you've all been told when we were here a year ago at Pork Congress, that was pending in front of the U.S. Supreme Court. Very, very few cases get accepted by the U.S. Supreme Court for decision. So when that came out in March, that was huge right there that the U.S. Supreme Court accepted it, okay? We don't know what they're going to do with it. Many of you may have listened to the oral argument that was in October. It was, and I think it still is available online. I watched it. And I was talking to somebody yesterday who said, boy, after I heard the questions they had for the attorney for National Pork Producers Council and American Farm Bureau Federation, I was sure we were going to lose. Tough questions, probing questions. Then the attorney for California and the other defendants spoke. Well, no, the next attorney was for the Department of Justice, who was supporting National Pork Producers Council, which is pretty big in itself. sound a little better maybe. And then they were just as hard on the attorneys for California, et cetera. My analysis was, we can't really tell by their questions. Sometimes you can after you hear an oral argument, but they were hard on both sides. The real issue is there a legitimate state interest there for California to adopt the law they did? Because it reaches far beyond its borders, and its primary effect, of course, is on other states, because you all know this, because not many sows are in gestation in the state of California. They are large consumers of meat, but when they start regulating how sows can be housed, it falls primarily outside of the state of California. Thus the challenge that it's unconstitutional as infringing on interstate commerce. I won't get into the details of what it, many of you know what it does. We have it in the outline here. Massachusetts Question 3 is similar. It's not part of the Supreme Court appeal, but Massachusetts Question 3, the court, based on an agreement of the parties, including MPPC, as there is a stay on that law going into effect, as there is in California, basically, until the U.S. Supreme Court rules. Again, I started to say this, the analysis is there a legitimate state interest in California adopting this law? What is their reasoning? And you and I know it's not related to the health of the meat or anything like that. It's an interest on how animals are raised, and a moral. Some referred to it as a morality issue. I'm not sure about that. But the question that I found most interesting from the Supreme Court justices was, well, couldn't you have done something else besides ban it? Leave it up to the people. Let them decide whether, not to vote on whether it comes in or not, but whether they want to buy it or not. Let the marketplace decide. Those are probably my words more than theirs. But, label it. And I know there's issues with labeling meat, federal law, et cetera, but just let the meat go there and then let the consumer decide if they want to buy the meat that's been raised in gestation anyway. We're not talking the market hogs here. We're talking the gestating sows that produced the market hogs that ended up in the meat case. So I thought a lot of probing questions on both sides of that case. And I'm sure Michael will get into that today. And I'm sure Michael will tell, and you ask him if he doesn't, but Michael will tell you as producers exactly what you should be doing right now. You can tell him I said that, because we don't know exactly what to do you go ahead and start converting, or I think you have to decide what's best for your operation. And I know some producers are looking at the marketplace. If it's going to reward me, maybe I'll do it. If others are saying, don't want to be told by the state of California how to raise, how I should be housing my sows. So, again, okay? Any questions? All right. Ben? Manure easements. Let me get the slides going here. Switching gears here, as I talked about. Let me get back. All right. Slide 29, if you're keeping track. All right. Here we're talking about, we really are shifting gears here, but there's still the theme of manure here. This is an agreement between the owner of a hog operation, cattle operation, whatever it is, and someone who owns the land where that manure is going to go, if that person is other than the person who owns the hog building or the cattle feed yard, etc. As I mentioned in the introduction, it's interesting to a lot of people and many attorneys, etc., that the court cases we've seen have not been about, oh my gosh, who has to take it? I can't get rid of it. No, they're fighting over it. I started out with the court cases here because I thought that might kind of set the tone for us to go through some of the issues you'd want to look for in agreement here. There was three cases here in your slides, and what I want you to do is look at, and if you're keeping track here, circle the fact that every one of these cases was not a lawsuit between the original owner of the building and the owner of the land. These were all cases after the building had been sold. Okay? That's significant, because what I think what often happens, not always, but when they're building the hog operation, the cattle operation is sold, that new owner is often looking at it and saying, I can use that manure. I wonder if I can keep it instead of providing it to whoever is the landowner under this manure agreement. And that's what these cases were about. First one in 2009, the court ruled that just because the restriction on the landowner getting it was in the deed, that wasn't important. That was not binding because the buyer doesn't sign a deed, only the seller signs a deed transferring it. So that's the legal analysis. And the manure agreement didn't, it said that he wasn't required to provide it to the landowner. So and then on to slide 31, another one where the hog buildings had been sold. And, in the interest of time, I think I skipped one there. Slide 30 is another one in 2016. The real estate purchase agreement said the buyer would provide a written manure easement. They didn't. And so they ended up in court when the new buyer said, I don't want to provide that manure to the landowner. I want it for whatever. Again, the whole point of these cases are manure is so valuable, number one, they will go to court to fight over who gets it. But more importantly, let's take a look at starting on slide 32. I'll try and move forward here. What I often run into is, DNR has a rule on what a written manure agreement has to include. Very, very basic. And folks, don't stop there if you're advising livestock producers and landowners on what should be in a written agreement. That just satisfies DNR. And it's not enough to keep you out of trouble, so to speak, as we've seen in these cases. What should we, slide 33, some basics on the agreements, who should be parties to the agreement. Tenants are often involved because we know a lot of the land is not farmed by the owner of the land. I think it's important when you're working on these agreements to have the tenant involved, but it's important in my opinion, the last bullet point is the most important there on that page. Rather than, the landowner, both as a matter of real estate law and for DNR, has to sign the manure agreement. The landowner getting the manure for liquid manure buildings anyway under DNR rules, but under real estate law as well. If the tenant is going to be farming it, and if the landlord has to pay something to get that manure, it's really on the tenant. So the key is to have that provision in the farm lease. So you've got your manure agreement that gets recorded with the county recorder, but if the landowner is renting it out, get the terms in the farm lease that require the tenant to pay the costs of application, etc. Okay? I think I want to get to some of the DNR stuff here, and we've got 15 minutes yet, 17 to be exact. Anyway, I'm looking at the slides here. I think let's go to slide 36. This is probably one of the most important slides here. What an agreement, a written agreement is great, but often a written agreement that doesn't cover all the details is maybe worse than not having a written agreement. I've been asked to review quite a few manure agreements, manure easements. Well, let me stop there. Let's see, where do I have the discussion? Okay, slide 37. If it's a true easement, what's an easement do? It gives somebody else the right to do something on somebody else's property, the permission, like to go on the property. Here, a manure, I'll call them an agreement, that simply gives the livestock producer an easement to apply manure on the property, probably doesn't require that livestock producer to give them or to provide them with the manure by itself. It just gives them the right to do it. So along comes that second buyer or the second owner, and the second owner says, well, yeah, that's great. You give me the right to do it, but I don't want to. I want the manure. And then the landowner says, hold it. My understanding was I was to get that manure. That's where the fights come in. What we need is the agreement if the landowner wants that manure, otherwise they wouldn't sell off that 5 acres for that building to be built. If that's what the landowner wants, that agreement needs to be clear that, yes, the livestock producer has the right to come on the property to apply manure or to provide it to me, and I'll hire somebody, however it's worked out. But it also has to require that the livestock producer provide the manure, require that the landowner gets it. Those are key terms to be in the agreement, and then what happens when it's sold? The agreement must say, here's the term, run with the land. Get it recorded with the county recorder. DNR doesn't require that, but record it with the county recorder and state that it runs with both parcels of land, the livestock operation and the land where the manure is to be applied. That will cut down on a lot of the issues we see. Okay? There's some other factors there. Let me take the other one I want to be clear on. I think I have in a previous slide, but I'm not going to go back. You'll find it. State, what do they pay? Okay? I'll just give you an example. Got a contact from actually Illinois, but it's regarding the manure agreement. The manure agreement says that, one, they don't have to provide all the manure. It's an easement. But two, it says if the manure is provided, that the landowner has to pay the cost of application. Okay. So now we have a new buyer, or owner of the livestock operation has come along, and the owner wants, the livestock operation owner has agreed, I'll provide you with the manure, because their land is pretty much right around the operation that isn't very feasible to take it anywhere else. But they said, you're going to pay more for it now. You're going to have to pay, because fertilizer is so expensive, you need to pay, in addition to the cost of application, the value, some fertilizer value. And the landowner said, well, wait a minute, I haven't had to do that before. It only says I have to pay for cost of application. What I like to see, and quite a few do say this, you say, landowner will pay for the cost of application and no other consideration or payment will be required. I think if it only refers to cost of application, my analysis is you don't have to pay more for that. But really, all the details you can set out, the better. Hopefully we'll keep you out of talking to people like me. Okay? Yes, sir.
So things have changed a lot since those buildings were built 10, 15, 20 years ago. And today, with moving manure more with semis, you can take it farther distances. So those places that we're now putting manure, have easements to put manure on, wouldn't have been in any kind of a recorded with the county recorder's office. So how do you, is there a way to, you have to go back and renegotiate that, which probably they're not going to want to do.
All right, I'll repeat your question here if that's all right, so that it gets on the tape. You're saying things have changed a lot, and now we are able to haul manure further economically, right?
And it makes sense from the standpoint that you're not going to build a lot of P&K where you keep applying. You can use it. It's more cost effective to move it further.
Okay, and what he said was it's more cost effective to move it further because that land can use it probably better than the land that is closer, and it'd be more environmentally responsible, right? Your point, here's where I got to say, well, it depends. If if those agreements with the land that is close, if they require that the manure goes on that property, and you want to take it further, you probably have a problem. But if there's simply easements that give you the right to do it, then you could take it to that other land. Now, you've asked me about that other land. We never had agreements with them. You can get one now, right? I'd say get an agreement with that land, one, to satisfy DNR, but more importantly, to just to make sure everybody understands what the terms are. Does that, I mean, yeah, once you satisfy DNR, you can have a verbal agreement to take the manure further. But then, we all say get it in writing and get it recorded so that if that land sells and you're taking it there, you have the right to take it there. Now, you might say, well, we'd be glad to take it somewhere else, right? So I have a feeling, I'm not sure, I didn't try and dance around your question, but the point is, if it makes sense to take it further, make sure the closer land doesn't have all the rights to that manure, because if they do, then you've violated that agreement and they're not going to be happy. But if you aren't locked into the closer land, yeah, take it to that land, but I'd still encourage getting a written agreement. Does that work? Okay. Well, anyway, yes, sir, Mike.
Okay, slide number 35, final bullet point there at the bottom about fertilizer application records. How detailed do those have to be, and do we need to keep those in with the manure management plan?
And you're asking me that, you're talking about DNR regulations here, right?
Specifically, yeah.
Yeah. Okay, I can give it, I don't have I'll be glad to look at the rule and get back to you, because I know who you are. But as I recall, I think the records of other manure application, first of all, they have to sign the notice of intent to start with, what they're going to put on. And I think they just have to be the records, and then DNR can ask to see them, but I don't believe they actually have to be with the MMP. But I'll take a look, and anybody else who's interested, let me know, and I'll get back to you. Does that help?
Yeah.
Okay. Again, the whole point being under the DNR regulations, you can't apply more manure than what either the nitrogen limit allows, or if you're on the phosphorus index. And that's one of the issues. We got about 10 minutes left. I want to get to some of the DNR stuff. But any other questions on? Yes, sir.
Easements that you used to sign for the life of the building, how long do those easements run?
Okay, the question was, if the easement says it's for the life of the building, then it's for the life of the building. So if that's what the easement says, and there are a lot of them that say that, there's no time limit on easements unless you put one in there.
There isn't. Okay. Thank you.
You're welcome. Okay. All right. Now we want to move to, let's see, proposed DNR rules. I'll just briefly talk about this. Many of you know that in August, DNR came out with an informal rulemaking proposal. What was it, 80-some pages, I forget. I know you all read it. Ben read every word I know he did.
How about that?
Yeah. Let's just say, in the interest of time here, that's on hold, okay? Comments were provided, and the DNR made some changes. You can take a look at those if you want. It's available. Provided it to the governor's office for what we call pre-clearance, and that's where it is right now. And then, of course, did I have the moratorium on the last slide? Yeah, the bottom there of slide 39, on January 10th, the governor issued an executive order pretty much putting all administrative rules, not just this one, but all administrative rules on hold, and until an analysis is done if those rules are necessary, etc. And it appears that moratorium applies to this rule. I just talked to some folks at the DNR, and they're still kind of taking a look at it with the governor's office to see if the moratorium applies. But to me, it appears it does, so it's on hold. What was in that rule, slide 40, the major issues were karst, building in karst terrain, and if you're... I hate to say primarily the northeast part of the state, but at least the northeast to eastern part of the state is where we see karst. That's a type of bedrock, rock formation, subsoil, etc. That is, I think, fair to say more susceptible to groundwater contamination, etc. So if you're in karst terrain, you know it. And that's the major part of the rule is changing some of the construction requirements there. And then some floodplain regulation. Again, it's at the governor's office now. I'm told by DNR. They did tell me probably when the hold is lifted, there will be more changes to that. The key point I have for you right now, it's proposed. Not that you shouldn't be interested in it, but don't read any of that and think it's the rule. or the law right now, proposed. We still have the same rules we've had, no changes yet. Okay? All right. What do I want to hit in 5 minutes of the DNR rules?
Can we talk a little bit, Eldon, about manure management plans and keeping those up to date and what producers should know about that?
Yes, we can. All right. How's that for a setup? Go to slide 47. Okay. Some of you may have seen in the news, at least certain news, how many get the Iowa Capitol Dispatch email newsletter? Primarily covers, and there's a website, covers what happens, with legislation, etc. But they have started covering more closely DNR penalties, orders, enforcement actions. And there have been several lately. Ben emailed me one morning after he read the dispatch and said, "What's going on here?" There was a list of how many, 4 or 5 operations?
Yeah, it was a handful.
That had been fined for not getting their manure management plans in on time. And Ben's question was, has the law changed? What's going on here? The law has not changed. We haven't had the last rulemaking was in 2016. This part of it hasn't changed since 2002, roughly. And what I have up there is you're required to annually or to submit an annual MMP update to DNR in the county, either hard copy or electronically. And if there are no changes, you say no changes. Or if there are changes, you have to show those changes. And the rule also says DNR is to stagger the due dates and, quote, notify each confinement feeding operation owner of the date on which the MMP is due. That notification, here's the history. DNR, when updated MMPs went into effect as a result of the 2002 legislation, DNR was notifying everyone every year, right? You got a notice. DNR stopped doing that a few years back. I don't have the exact date. Their point that they have noted, their notification requirement is done when you are originally notified your MMP will be due December 1 every year. It's always the first of the year, right? Or the first of the month, and it's that date every year. They feel they have complied with the notification requirement in the law, and so they don't send an annual reminder every year anymore. That has caught quite a few producers off guard, and what DNR has been doing is sending what we call an NOV, a notice of violation. Doesn't carry a penalty with it, at least initially, just says you're in violation. Your MMP didn't get filed by the first of the year. And many DNR field officers, when they'd go out for an individual site inspection, some, I'll put it that way, would say, well, just get them in on time, but no penalty. Well, DNR has changed that here in the last year. And I have their bottom bullet point. DNR enforcement actions for repeated failure, and the legal counsel told me yesterday, 3 consecutive years of being late, you're going to get a penalty. Okay? The days of just living on the NOVs and no penalty are over. Get them in on time, folks. That's the way they are looking at it, and that's why you're seeing these enforcement actions more than we used to see, because they've changed their enforcement policy.